Let's get us. All right, we are live and recording. Hear ye, hear ye, hear ye, all persons having anything to do before the justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. My name is James Lemire, and welcome to the January 7th sitting of the Massachusetts Appeals Court. The panel consists of myself, Justice Ditkoff, and Justice Grant. And this morning we have 6 cases. We will try to act as though we were in the live courtroom. So I would advise you that you are on camera. So when the opponent is arguing, be aware that you will be seen and your presence is visible. You each have 15 minutes. There's no rebuttal. The clerk just explained the clock system, and you'll see the clock count down. And with that, I will introduce the first case for this morning. It's docket number 2019 P1657, Bass River Tennis Corporation versus Manuel Barros. Mr. Sullivan?
Yes, Your Honor.
Go right ahead.
May it please the court, my name is Attorney Dennis Sullivan. I represent the defendant appellant Manuel C. Barros. Our purpose here today is to determine whether or not the Superior Court judge allowed a motion and order for the auction of a 20% members' interest in a limited liability company in order to pay off a previous judgment issued by that court in 2018. Our position is that that Chapter 156C, the limited liability company statute, does not allow for the auction of a member's interest in a limited liability company in the Commonwealth of Massachusetts. This is based upon the Section 40 of Chapter 156C, which allows a creditor of a individual member to petition the court for an order, a charging order, to attach the distributional interest of the member in the limited liability company. There is no, let me just take a step back. It says that the court may order it, may meaning that the court would balance whether or not it was necessary in order to pay off the judgment. There is nothing in the statute about foreclosure of the distributional interest, which is what some other states have done. There is also no mention of a sale of the member's interest in the limited liability company.
And Counselor, why can't the assignment under Section 40 be a permanent assignment?
Your Honor, the assignment under Section 40, if you read what is in Section 39B2, it is only for the distributional interest and goes away as soon as that creditor is paid off and then that distributional interest returns to the member.
Well, that's not what 39 says. 39 says that once all your interests are assigned, you're not a member anymore, and the other members can accept that person as a member if they want to, but they don't have to.
Nope.
So why can't that be done here in this context where 40 calls up 39?
Your Honor, I believe it says in 39B2 that, make sure I'm reading it correctly. Unless otherwise provided, the member, an assignment means that they're entitled to share in the profits and losses. That's what the section 40 says, that they are an assignee of the limited liability, only has the rights of an assignee under the limited liability company interest. It says that, further goes on to say in 39B2 that unless so otherwise provided in the operating agreement, the pledge of or granting of a security interest, lien, or other encumbrance in or against any or all of the limited liability company interests of a member shall not cause the member to cease to be a member or to have the power to exercise any rights or powers of a member.
Sure, but if you read the sentence before that, it says a member ceases to be a member and to have the power to exercise any rights or powers of a member upon assignment of all of his limited liability company interest. So why can't the judge do that? And then your client's not a member anymore under the statute.
Because, I'm sorry, Your Honor.
No, that's my question. Go ahead.
Your Honor, I believe that says a member ceases to be a member and have the power or rights of a member upon his assignment.
It doesn't say his, it just says assignment.
Your Honor, the way I read that is that under section 40, it's only for purposes of paying off the judgment. It says this chapter does not deprive any member of the benefits, strike that, only has the rights of an assignee, and that the judgment creditor never becomes a member.
Where does it say that?
They only have the rights of an assignee, and an assignee is not a member.
He is under 41A if the other members accept him.
That's true, or unless it's otherwise prohibited by the operating agreement.
So do you read 41A, the or being an and there? I mean, it looked to me like it said either the approval of the members or upon compliance with the procedure, but do you read that as requiring both of those?
I read it as upon approval by the other members or upon compliance with any. There, at this point, at the point that this was done, the only member at that time that had been accepted by the limited liability company was Mr. Barrows. So they would have to then comply with the other procedures in the written operating agreement. And I believe section 20 also says that a person may be admitted upon compliance with the written agreement.
So is it your position at that point, Barrows had 100% of the LLC?
No, it was in litigation. There's a securities purchase agreement that Mr. Barrows had upon the compliance with certain conditions that Mr. Greenberg and Mr. LaPierre could become members of the limited liability company. But there was litigation going on, and Mr. Barrows's exclusive interest at that point was a 20% interest, which is what the creditors were trying to sell.
So as I understand it, the issues before us today have to do with that sale and the way the auction was conducted. Are you arguing that the auction shouldn't have been conducted at all, or the procedure was improper?
I would say both, Your Honor. I don't believe the auction should have been conducted at all, because I think that the chapter 156C section 40 only allows a charging order, and therefore there was no reason then to hold the auction. And we also believe that if you do not agree with that position on the fact that the charging order is the only means of relief, that the auction sale should not have gone forward in the manner that it did, because there were a limited only two bidders for that interest, and they were the creditors themselves.
Considering that your
Section 40 says the court may charge. It sounds like you're interpreting it to say the court must charge.
No, I'm not, Your Honor. I'm saying that we believe that we believe that the only thing the court can do is to charge, but that the court's not required to charge. This is in the nature of an attachment in the lower court, where a judge doesn't have to enter the attachment, but he may do it. He or she may do it. But I believe that the statute is a comprehensive statute passed by the legislature in 1995, and displaces by implication any other remedies that would be available to the creditor. So that we believe that the only remedy available here, as stated by the legislature, is the charging order.
What do you say was the fair market value of the 20% interest in Tozier?
Your Honor, I would believe that the fair market value of interest in Tozier, and I don't have I'm an attorney, I'm not an appraiser, so, but based upon the value of the property that was owned by Tozier at the time, and the outstanding value of the mortgage, I would say that based on my calculations, it was probably worth between net equity, probably about $2 million. And therefore, a 20% interest in that property should have been about $400,000. And therefore, the buyers, who were the only people at the auction, together only paid $75,000, of which $65,000 is a credit against the execution. We believe was well below what the fair market value should have been for that auction.
So your client didn't attend the auction?
No, he did not, Your Honor. He didn't. You know, at the time, I was trying to get a stay from the Supreme Judicial Court, and we thought we would be able to get a stay and then be able to move forward that way.
Counsel, you didn't file a notice of appeal of the approval of the special master report, is that correct?
Your Honor, the approval of the special master's report was really just for the special master's fees. It was not for approval of what he did at the auction.
You didn't file anything. I mean, how is the way the auction happened before us, when your last notice of appeal is July 18th, 2019, of the order setting up the auction, and you haven't given us any appealable order that postdates the auction? Well,
you know, I felt that since under the order of the special master, the bidder or the sub-bidder could apply to the court for a approval of the sale, and they did not do that. That therefore, I did not have an order from the court that I could appeal from. And so I was going forward with that the court did not have the power to enter the sale order and go forward on that basis.
We received a document from you yesterday that's captioned a status report that appears to be, in another name, a motion to amend your brief. Is that correct?
Yes, Your Honor. It's I discovered those in going through in preparing for argument. I called the appeals court clerk's office, and that's what they advised me to do in order to help the court understand and to clear up the discrepancy, the missing information in the brief.
So we basically need to read your status report line by line, word by word, and figure out what's different in it from what was in your brief.
Your Honor, the only difference is under the issue presented, I added section 40 that was inadvertently left out. And then I replaced the whole first paragraph of the statement of facts section because it didn't say what the value of the judgment was on December 12th, 2018. And kind of ran into what Mr. Barros has already paid towards that outstanding judgment, where he's paid $520,000, but the judgment itself was for a little over $755,000. And I want to clarify that from the court. It appears in other places in the brief, but I felt I felt an obligation to correct that for the courts. Your Honor, Your Honors, the implied the comprehensive nature of the LLC statute allows, even though it doesn't specifically say that Chapter 214, Section 3, subsection 6 is repealed, because of the comprehensive nature, it can repeal things because it does not say that, because it doesn't include them within that statute. And based upon that, we believe that the charging order is the only relief available to the plaintiffs in this action, and therefore is what should have been ordered. The fact that the plaintiffs are claiming that there's no money being given out, they get no money from the charging order, that was a contractual provision in the securities purchase agreement that they drafted that caused Mr. Barros, that causes Tozer to only pay to the plaintiffs any amounts of money that are generated by 31 Tozer Road LLC to the plaintiffs, and that Mr. Barros actually has to guarantee that if any such monies are paid, that he will ensure that they go to the plaintiffs in Bass River Tennis Corporation and the individual plaintiffs. And on that.
All right, your argument has been heard. Mr. Downs?
Members of the panel, may it please the court, Joe Downs on behalf of the plaintiff appellees, Bass River, Mark Greenberg, and Mike LaPierre. This court should affirm the trial court's order appointing the special master principally for three reasons. One is that the arguments in Mr. Barros's brief were not, some of them were not timely raised below. Two, there was no abuse of discretion by the trial court in appointing the special master to conduct the reach and apply sale, particularly in view of the record before the special master, which included Mr. Barros's longstanding delay in attempts to frustrate my client's ability and attempts to collect on the judgment, Mr. Barros's statements, repeated statements to my clients and to the court that he would satisfy the judgment, and opposed post-judgment discovery on that basis, only to find out that Mr. Barros' annual salary was $10,000 a year, and he had no reasonable prospects of satisfying the judgment. And against those facts, Your Honor, there was no abuse of discretion for the court to exercise these equitable remedies to do what was necessary.
Mr. Downs, what do you say to the argument that the charging aspect of 156C is the exclusive remedy for collection against an LLC, and that any other judgment collection tools are unavailable?
So we disagree. And as stated in our brief, Your Honor, there are two ways by which the charging order, where a statute could repeal, abrogate, or supersede a prior statute. First is by direct enactment, where the statute itself explicitly says we are abrogating a prior statute. It doesn't do that here. The other is by clear implication, and that is not to be inferred lightly. It only happens if there are two statutes that can't coexist. They can't stand together because they're so repugnant and inconsistent that the court needs to do something about it. Here, the reach and apply remedy is a longstanding remedy. It has coexisted with the charging order for the past 25 years. Mr. Barros is not giving us a hint of any legislative intent for the charging order to displace, abrogate, or supersede the longstanding remedy under reach and apply. So we reject that argument. We do not believe it is not an exclusive remedy, either explicitly or implicitly. The other one thing I wanted to clarify, and this is an important point, is that my clients indisputably were the 80% members of Tozer at the time of the auction. There was a BLS judge. There was a BLS summary judgment, and that summary judgment was dated September 8th, 2017, that declared my clients the 80% members. More importantly, there was a BLS judgment that entered on June 14th, 2018, that declared my clients 80% members. Now, Mr. Barros appealed that judgment, but this court affirmed that judgment by order dated April 3rd, 2020. The auction took place in August of 2019. And at the time of that auction, there was a BLS judgment that had declared my clients 80% members. And that the fiction that Mr. Barros was 100% member, it ended when this court affirmed that judgment. So at the time of the auction, we were the other members. We were the folks who could welcome any other member or enlarge our own membership. And so whatever Mr. Barros has to say about the statute in particular, section 41A1 is not a bar to the sale.
Counselor, would you agree that even if reach and apply applies in this situation, that a judge can't force the other members of an LLC to accept a judgment creditor as a member if they don't want that, unless the agreement allows it?
Yeah, I don't agree in the sense that the Tilcon case speaks to that, but I also don't think those are the facts here in the sense that we were already the 80% members. So it's an academic argument as applied here. I think the Tilcon case says the court isn't bound by anti-alienation restriction, assignment restrictions, self-imposed ones, such that if Barros was the 100% member and we were only purchasing 20% for us, we were 80%, we were just purchasing the final 20%. So I don't think those are implicated here. The last piece, Your Honor, just to talk about the fair market value, the argument here, first, it wasn't raised below in any form or fashion. The special master's report wasn't appealed, but what's before the court isn't supported by record evidence. It doesn't rise to the level of developed argument. And what it also omits is that Barros conveniently did not tell this court that this auction, Tozer was in bankruptcy. So whatever he has to say about value, he forgot to say or did not say, by the way, Tozer's in bankruptcy. And as this court is aware, that's going to have an effect on the value. What Barros also didn't say is that he has subsequently sued Tozer for an alleged $1.3 million debt. So whatever Barros has to say about $2 million in equity, it omits the case that he's now filed, which is going to cost my clients and Tozer at a minimum, significant legal fees. All of these things were factored into the mix, including the fact that Mr. Barros has noticed 11 separate appeals. And this litigation has been ongoing in various courts across the Commonwealth since 2012. The Barros factor was a significant factor. And notwithstanding all of those things, my clients made a good faith $75,000 purchase of the 20% interest of a company that was in bankruptcy that Mr. Barros was attached to. So unless the court has other questions at this point, we'll rely on the arguments contained in our brief.
All right, seeing no questions, the case has been heard. We'll take it under advisement. Thank you very much, gentlemen.
All right, we're live and recording.
All right, good morning. This is the second case for January 7th, 2021. The case is docket number 2019 P1245, Finance versus Francesca, Attorney Gainey.
Good morning. May it please the court, Kevin Gainey here on behalf of the appellant Ithaca Finance, LLC. This case arises from a motion seeking to vacate a judgment of the land court in a tax foreclosure case. The principal issue raised on appeal is whether the land court had abused its discretion and committed errors of law in basing its decision to vacate the tax foreclosure judgment on findings of fact that benefited from no evidentiary support at all in the record, and whether the court inappropriately shifted the entirety of the burden of proof from the moving party to Ithaca Finance. With regard to the background of the case, some of the dates, the initial dates, are, I think, relevant to this court's review of the matter and the issues presented. First, the property was initially owned by a woman named Felicia Hilario, who obtained the property in April of 2006. Thereafter, sometime in 2006, the city of Lawrence, which is the municipality within which the property is located, found itself in what their council characterized as a desperate need for funds. And the city began to look at its inventory of municipal tax takings as a potential source of revenue for the town. So in 2006, Lawrence solicited bids for investors to purchase their tax lien portfolio or some portion thereof. On October 30th of 2006, an entity named Plymouth Park, doing business as Expand, submitted a bid to purchase a portion of this inventory. And less than a week later, on November 3rd of 2006, the city of Lawrence accepted Plymouth Park's bid. And sometime thereafter, in June of 2009, they actually consummated the assignment of a bulk of the city of Lawrence's tax takings to Plymouth Park. So again, that happened in June of 2009. On February 16th of 2010, Plymouth Park recorded an instrument of taking with regard to this particular property held by Ms. Hilario. And pursuant to the plain language of General Laws, Chapter 60, Section 54, upon the recording of that tax taking, title vested in the holder of the tax taking, subject only to a right of redemption. So again, that was on February 16th of 2010. It was not until July 31st of 2012 that Ms. Hilario sought to convey whatever interest she held in the property to the appellee, Francisca Ledger. As you likely saw in the materials, the attorney who administered that closing made some significant errors. It appears that although she received money for the obtainment and recording of municipal lien certificate, it's not clear whether that attorney actually did that. The tax taking, again, was a matter of public record as of February 16th of 2010. Nevertheless, as part of that closing, those outstanding tax liens were not satisfied. And subsequently, Plymouth Park assigned some of the tax takings, including the tax taking regarding this property, to an entity named Ithaca Finance. So this time frame is relevant because one of the principal findings by the land court with regard to its decision was that Plymouth Park had an obligation to engage in communications with Ms. Hilario for the purposes of essentially reaching a workout regarding outstanding tax liabilities. The statute actually doesn't include that requirement. What it suggests is that an assignee of tax takings, their plan to communicate with property owners should be considered when evaluating the relative bids. In this case, we don't know how many bids there were. We know that the bid was submitted on, again, October 30th of 2006, and it was accepted less than a week later on November 3rd of 2006. And we know that in the materials that Plymouth Park submitted, they did outline their intentions and their infrastructure to communicate with property owners. We have a period here in excess of 3 years from the time that Plymouth Park recorded their instrument of taking to the time that Ms. Hilario deeded essentially her right of redemption of the property to Ms. Ledger. And the moving party, Ms. Ledger, offered absolutely no evidence, either testimony from Ms. Hilario or any representative of Plymouth Park or Plymouth Park's principals, initially Bear Stearns and subsequently JP Morgan, no evidence at all that any communications did not occur between Ms. Hilario and that holder of tax title. We are left with a vacuum as to whether they engaged in daily or weekly communications. And in the absence of any evidence to the contrary, the land court made a finding first that the communications were required by the statute, which they're not, but more importantly, that they did not happen. Again, Ms. Ledger.
Counselor, can you tell me where that finding is?
Yes. If you look at the land court's decision, on page 2, first it says, I find and rule that Ithaca and its predecessors failed to comply with their statutory obligation and binding contract conditions of the assignment, requiring them to communicate with Ms. Ledger.
Ledger, not Ms. Hilario.
Again, but it's important, I think, to focus on this 3-year period between the taking and what happened when Ms. Ledger got the property.
Well, why is that? I mean, let's assume that Plymouth Park talked to Ms. Hilario constantly, every day.
Sure.
How did that create due process for Ms. Ledger, who wouldn't know that, who wouldn't have that information?
Because I don't think I think that's a contractual issue, not a due process issue. The due process issue applicable to this case, and it's the due process standard that's been applicable to these tax cases for quite some time, Your Honor, is that the property owner be given notice of the case, notice of the nature of the case, and an opportunity to appear. It's established in this case that pursuant to Chapter 60, Section 66, the land court properly identified Ms. Ledger as the property owner and properly served her with the citation, satisfying her due process rights and providing her with the due process necessary with regard to this case. And she acknowledged that she signed that green card, which is part of the land court's record. And that's the due process that was owed to Ms. Ledger in this case. And it was satisfied. This expansion of due process to a requirement for communication, which again isn't required in the statute, is an improper extension first of the due process standard. And I think it's not supported by either the law or the facts of this case.
Well, I mean, let's explore that.
Sure.
First of all, is it important that Ms. Ledger actually read the citation, in your view?
Is it important?
Is it important? Is it a due process problem if she didn't read the citation?
No. What due process requires is that she be provided the notice necessary by the land court. That's what the statute provides, and that's what the cases provide.
Right. I'm looking at the citation, and I'd like to know what in it, in a context of someone who had never been contacted in any way whatsoever about a tax deficiency, would understand from that she was at risk of losing the property in this case.
I apologize. I don't have the citation open for me at the moment, but I will have it open in just a second.
Sure. It's at 145 in the. I think
Thank you.
appendix.
I apologize. Did you say page 45?
145.
Oh, thank you. Again, well, I can tell you from my recollection, but again, it's not, I don't have it at that page, but the notice from the land court, I'll say a couple of things. One, it identifies the court and the property, and then it's a tax lien case. And I think in this context, it's extremely important to note that that citation is the form citation used by the land court in each and every tax taking case. And if this court were to find that that notice was not sufficient to satisfy the due process requirements, then it would essentially lead to a holding that every single notice that's been sent by the land court in one of these tax cases is invalid and deceptive.
I don't know if that's true, because I assume the land court assumes that usually the statutes have been applied to and that the owners have been communicated with about the tax lien. And so that they're sending these notices in a context where the owners already knows that there's a tax lien, and then they get this. But in a situation where the owner has gotten no communication whatsoever from the tax taker, how are they supposed to know that a complaint to foreclose all rights of redemption means that you're going to lose the property if you don't pay whatever it was at that point, $7,000 or so dollars?
I think that your assumption is without foundation, because in the majority of these cases, the tax taking is undertaken by a municipality directly, not by a third party assignee. And in that case, Section 2C of Section 60 wouldn't apply at all. And the only notice that a taxpayer would have received ever would be this notice from the land court and the regular tax bills, which again would have been sent in this case as well.
Well,
So I think
minimally, wouldn't they minimally have received the notice of assignment to the third party?
yes, and in this case, the notice of assignment was sent to the property. The assignment
Was sent to the property.
Yes, it was sent to the property, and it was addressed to Felicia Hilario and Francisca Ledger, who both lived at the property. And
But the judge found, based on Ms. Ledger's testimony, that Ms. Ledger didn't receive it.
okay,
And therefore the presumption of the mailbox rules was rebutted.
the judge made actually 3 findings based on the service of that letter, none of which are, I think, can stand. The first was that Ms. Hilario actually received the notice. Ms. Hilario didn't testify at the hearing. There was no evidence that Ms. Hilario received the notice, yet the court found that Ms. Hilario had received it. The court further found that Ms. Hilario received it and deceptively hid it from Ms. Ledger. There's, again, no evidence that that happened.
But can't the judge apply the presumption of the mailbox rule to infer that Ms. Hilario received it because she's one of the addressees?
Sure, but why can he make that presumption that Ms. Hilario received it, but not that Ms. Ledger received it? All
She
Ms. Ledger said
testified.
is that 4 years prior, she did not remember receiving the letter. Her testimony was as to her recollection, not whether she actually received it. And if that's to be accepted, then the mailbox rule will no longer exist in the
She
Commonwealth.
testified, I never received that letter at page 21 of the transcript, and she testified she had never heard of Ithaca Finance prior to June 2017 on page 16 of the transcript. So how can you say there's no evidence that she didn't receive that letter?
Because it was 4 years prior. And again, Your Honor, if this is to be accepted, then the mailbox rule no longer exists in Massachusetts. If somebody can say that they don't recall receiving something 4 years prior, then no longer can that presumption survive in Massachusetts.
Let me ask
All
you
right.
a question, if it's okay.
Yeah.
If you knew in March 31st, 2014, that Ms. Legger owned the property so as to send her a letter,
Mhm.
then why didn't you name her in the lawsuit?
I'm not sure why she was initially named, but that omission was corrected. And when the citation of the case went out in May of 2015, she was properly identified and notified of the case.
All right, the time has expired. There being no further questions. Mr. Corrigan, if you'd unmute yourself and in your argument.
Good morning, members of the panel. May it please the court. There is nothing nothing arbitrary, capricious, whimsical, or idiosyncratic about Judge Speicher's ruling in this case. It was certainly based upon a review of a plethora of evidence. Just by way of background, as the court is well aware, in the land court, judges are assigned to a case and see that case through to finality. So we, upon the filing of Ms. Legere's motion for relief from judgment, the case was assigned to Judge Speicher. We conducted a case management conference. We participated in discovery. We had a preliminary hearing, a full day evidentiary hearing. We submitted post-hearing briefs and requested findings of fact. There were closing arguments. My point being, Judge Speicher certainly has a command of the facts of this particular case. And for Ithaca to suggest that somehow this decision is based upon a lack of understanding of the facts, I think does a disservice to Judge Speicher. I will also say in response to the suggestion that the criticism of the service of the citation in this case suggests that all land court cases will somehow be called into question simply holds no water. As Justice Ditkoff mentioned, there's more to the issue in this case. That citation suggests to Ms. Legere that she may have an interest in a proceeding. It lists, or I should say it shows a caption involving an entity that she had never heard of ever in her life, Ithaca Finance LLC.
Yeah, but Counselor, it also has her name on it.
It does have her name on it, Your
There's a
Honor.
lawsuit against her in land court that she's supposed to do something on by February 29th, 2016. So if this said Hilario, I mean, I think there'd be no question that you're in the right, but it does say her. Why is that not adequate notice that there's something you need to look into for due process purposes?
Your Honor, I would say in a vacuum, if that were the only, let me just back up, Your Honor. I want to make sure that it's clear. At the evidentiary hearing, Ms. Legere was shown a copy of the green card. It was a somewhat near illegible photocopy. She was asked whether the signature appeared to be hers. She was very honest and forthright about that. She said that the signature did appear to be hers. She was also adamant that she did not recall signing for that document, and she was very adamant that she never received the citation. She admitted that she received the subsequent notice post-judgment from Ithaca Finance, but was adamant, and this is reflected in the transcript, that she never received the citation, and had she received it, she would have given it the same importance that she gave the June 2016 post-judgment change of ownership letter. And Your Honor, again, Judge Speicher was, it was his job to assess the credibility of the witnesses. He obviously found Ms. Legere to be very credible and forthright, and he credited her testimony that she never received that citation.
Did she? Where is that?
That is, Your Honor, the relevant portion of the transcript is the.
No, where are the findings? You said he credited that. He definitely credited that she never got the March 31st, 2014 letter from Ithaca, but where did he credit that she never got the citation? I didn't see it, but I might have missed
Yeah,
it.
yeah. No, Your Honor, actually, let me correct myself. The relevant portion of the judge's finding and rulings is page 21 of his decision, which is, I believe, the second to last page of the decision, in which he states that the denial of due process caused by Ithaca's and Plymouth Park's combined failures to comply with the conditions of the assignment requirements of the statute was not cured by Ms. Legere's receipt of the special citation served on her by the land court upon initiation of the tax foreclosure proceeding. So the judge did not make the finding that she did not receive it. However, Ms. Legere, in her testimony at evidentiary hearing in pages 21 to 25 of the transcript, which I believe is pages 24 to 28 of the supplemental appendix, was adamant, and she was asked repeatedly by Mr. Connolly that she did not receive the citation in this case. Had she received it, I'm not sure she would have understood its importance. It had a legal description of a property being owned by Felicia Hilario. I acknowledge that the caption did indicate by this point it had been corrected to reflect Ithaca Finance versus Francisca Legere. But other than that, Your Honor, Ms. Legere would have had no idea what that case was about. She had never missed a tax payment. She had never received any notice of a deficiency in any taxes. Clearly, she had not received the 12-day letter from Ithaca Finance that had been addressed very strangely to Felicia Hilario and Ms. Legere in the same address block. So even upon receipt of the citation, had she received it, she would not have known, in my opinion, what that case was about. But
Well,
more importantly,
does
Your
the
Honor,
citation, didn't the
Say that.
citation, counsel, didn't the citation put her on notice to inquire minimally? And wasn't the notice in and of itself sufficient due process?
once again, Your Honor, as I indicated earlier, in a vacuum, if this were the only issue, I'd be certainly fighting an uphill battle. But this is not the only issue. There were multiple due process violations prior to that. The purpose of the statutory scheme is to give notice to the taxpayer well in advance of a foreclosure proceeding that you have a delinquency that needs to be addressed. And if you don't, there are going to be some serious consequences.
Right, what are the notices other than the assignment to Ithaca were deficient?
There was no notice given to the city of Lawrence that Ithaca Finance had taken over the collection of and foreclosure of the tax liens from Plymouth Park.
But is that due process to her?
It is, Your Honor, because the city could have sent notice or published notice to its taxpayers that there was a new entity taking over the tax liens for the delinquent tax liens for the city. The city was never afforded that opportunity. That's clear, and former city attorney Body came in and testified that he was not aware of Ithaca's involvement in city tax lien foreclosure until well after the assignment, when his office received notice on some other case. I will also point out, Your Honor, and Judge Speicher could have found this but didn't. The record is very clear that upon the filing of that complaint by Ithaca in May of 2014, they were obligated to record notice in the Registry of Deeds forthwith. They waited 2 years to do it. In the grand scheme, Your Honor, this is sort of the modus operandi of Ithaca Finance. Their attempts at due process are simply mere gestures. They have no desire whatsoever to notify the taxpayer, in this case, Ms. Legere, because they have a scheme. It's a willful scheme to lay low, hope that there'll be a misstep by the taxpayer, that she won't take advantage of her opportunity to defend herself, and then eventually the right of redemption will expire, and they'll have this windfall of a property worth several $100,000 for a tax lien of only a few thousand. So I guess, Your Honor, in conclusion, there were multiple due process violations. Had Ms. Legere received the citation in this case, that would not have cured all of the other due process violations.
All right, but we don't have a finding that she did not receive the citation.
We do not. We have, we do not have a
I mean,
finding.
the only finding of not receiving is the March 2014 of Ms. Legere not receiving a notice, and that would have been, I believe, the notice of assignment is the March 2014 notice. That was the direct finding that the judge made, correct?
That was clearly a direct finding, Your Honor. And again, the judge had the opportunity, but perhaps didn't feel it was necessary to find that the Ithaca's obligation to record the notice in the Registry of Deeds was not fulfilled, because they did not record forthwith. They waited essentially until they filed their motion for default 2 years after the fact to record that notice. So I believe that the statutory scheme under Chapter 60, and in particular Section 2C, is designed so that there are multiple requirements by the foreclosing entity to provide some form of notice. And I think the hope is that at some point, the taxpayer is going to receive one of those notices, whether it's by the mail of the 12-day notice of assignment, whether it's the recording.
Can I interrupt?
Yes, please.
If Ithaca became the assigned collector in 2014 and sent the notice, would that have been sufficient if it was deemed received by Ms. Legere? And then subsequent the subsequent action in land court? Even if it wasn't recorded or served to the town, if Ms. Legere received that 2014 letter and received the citation, is there anything other statutorily required of Ithaca at that point?
Yes, Your Honor. Obviously, we have the issue of the communication, which Ithaca continues to disregard, although I think Judge Speicher stated it succinctly that once that representation was made by Plymouth Park in its bidding package, it became an implied contract, and it was binding upon Plymouth Park. And then obviously once they assign their rights and obligations to Ithaca, that becomes binding upon Ithaca.
As a
Ithaca
contract,
also
not a statutory requirement.
It's built into the statute, Your Honor, in Section 2C, subsection C1.
Well, it's a consideration, but
it's a consideration. It's a consideration, but once the representation is made in the bid, and the city or the municipality accepts the bid and enters into the contract to assign, those representations become binding upon the assignee.
As a contract.
As a contract. Furthermore, Your Honor, as I mentioned earlier, there was no notice of assignment to the city. Had the city received the assignment from Ithaca, taking a step further back, at least in my opinion, the statute says that subsequent assignments can only be made under the same terms and conditions and in the same manner as originally assigned. It's well documented that the assignment from Lawrence to Plymouth Park in this case was done through a public bidding process, that it required city council approval, but somehow the subsequent assignment from Plymouth Park to Ithaca can be done under the table with no notice to the city and no opportunity for the city to vet the company that's going to be collecting and foreclosing upon city tax liens. So
All right,
certainly the city of Lawrence should have been given notice and an opportunity at least to give its taxpayers notice that there's going to be a new company involved in the tax lien collection and foreclosure process. So simply sending notice to Ms. Legere would have solved maybe one other due process violation, but there were multiple in this case, Your Honor, violations that would have had to have been cured. And
All right, I'm going to cut you off here, Counsel.
okay,
Thank you very much. Any other questions by the panel? All right, there being no further questions, the case has been.
Oh, all right, perfect. We are now connected to the live streaming service, so we are live and recording.
All right, good morning. I will call the next case. It's docket number 2020 P106, Green Daily versus Sandwich Zoning Board and others. Council, we will have a 15-minute argument. If for any reason there is any technical problems, we will try to resolve them and make sure you still retain your 15 minutes. So that being said, we will start the argument with Attorney Madden. Attorney Madden.
Good morning, everyone. May it please the court. My name is Terry Madden. I represent Maureen Bailey.
We're having
The
difficulty.
plaintiff appellant to deny. Let's see if I can. Which is in the record at the record appendix, volume 4, which was denied on October 7th of 2019 without findings. And specifically, it relates to the installation, or the wrongful installation of what is referred to as an innovative and alternate denitrification septic system. In this case, it's a fast septic system, and it was wrongfully installed on the plaintiff's property. Prior to her purchase of it, she was not made aware of it, and the law requires that any purchaser of a property be made aware of any alternate septic system. Again, in this case, it was a fast system. It also required that it be recorded in the chain of title. In fact, specifically by law, a notice of alternative sewage disposal system under Mass General Laws, Chapter 21A, Section 13, and 310 CMR 15.0287, subsection 10 is required to be signed and recorded in the chain of title. But this was not done in this case. And in fact, it wasn't until the plaintiff purchased the property that she became aware that that fast system had been installed. And at that point, she began trying to find out how that can be removed. Unfortunately, that's where everything sort of started mushrooming. She reached out to the builder. In this case, it was McShane. She was thereafter referred to David Mason, who was one of the defendants in this case. David Mason, one of the key documents in this case is a letter that David Mason had written to her on February 1st of 2005, where it instructed her that she needed to remove a third bedroom. She purchased a 3-bedroom. She paid for a 3-bedroom. The difficulty then became the only way for her to get rid of this wrongfully installed system, which David Mason knew to be wrongfully installed, was to eliminate a bedroom. And then
Counselor, how do we know that he knew it was unlawfully installed? Where do I find that in the summary judgment record?
Okay, well, because the Department of Health, or the Board of Health, with David Mason being that health inspector, is required to keep contracts for each installed fast system or innovative and alternate or IA system on file in its office. There were a total of 6 fast systems that were installed in that 40B development. Only 5 contracts were on file in David Mason's office. So he was aware that the other 5 homeowners had in fact contracted and were made aware of the installation of that system. However, Ms. Daly did not have a contract on file. And in fact, there's several documents, including a letter that she had written to the installer of the system that she did not contract, for the installation of that system, and a multitude of emails to David Mason himself stating that she did not contract for that system and requested that it be removed.
Are any of those emails prior to the February 1st, 2005 letter?
Prior to that letter, no.
So all you have is the fact that there was no contract. From that, he knows it's unlawfully installed at the time that he sends the letter?
Yes, because that's correct. But by law, the Board of Health is required to keep those contracts. So if there's no contract, any reason. Another very important point is that this is, again, as I said, it was a 40B development. Now, the applicant, in this case, McShane, the comprehensive permit applicant, also the builder, requested approval from the Zoning Board of Appeals for the installation of the building of 31 single-family units on a 15.81 acre site. Now, this was about double the amount of units that the town of Sandwich would otherwise have allowed. Now, the planning board had the authority to waive those zoning restrictions, which it did under 40B. And in doing so, the aggregation plan, what's called grant of Title V nitrogen loading restriction on facility and credit land. Now, this is a document that allows for the building of the 31 units on the 15.1 acre facility land, and it limits the total number of bedrooms to 85 bedrooms. And now, in reliance on that, are 0.1 acres of what was considered credit land. Now, this credit land was supposed to remain vacant, and this was supposed to take into effect that there were 85 bedrooms on just over 15 acres of land. So that was the balance act that the planning board had conducted in order to approve the comprehensive permit. And the comprehensive permit itself only called for standard Title V septic systems. And there was no mention anywhere prior to the installation of these systems that these systems would in fact be installed. They were installed as George Dunham of the town of Sandwich, he had noted in his February 18th, 2003 letter, which is at Record Appendix 2, Volume 2, the developer received to write down the cost of these denitrifying septic systems for some of the homes to better protect drinking water supplies. They weren't required. However, David Mason, on the other hand, continued to insist that these systems were in fact required by the DEP.
Well, Counselor,
as it turns out,
Counselor,
required.
could you tell me, I'm looking at a letter from Mass DEP saying that the units were required as part of the aggregation plan approval. So could you tell me where in the record I'll find that these fast units were not required by the DEP?
It says that they said the DEP says they were approved, not required.
They were
So it was
the aggregation plan approval. That's what Julianne Tour says.
approval, but not requirement. So if you, there's a letter from the DEP dating back to 2006. It will be in the first volume, but I can't put my finger on it at the moment. But it comes down to approval versus requirement. Approval was after the fact, or after the aggregation plan was signed. So the aggregation plan was submitted to the Board of Health, to specifically David Mason, who signed it. He signed it on October 23rd of, no, I'm sorry, he signed it on, well, in any event, he signed it before it was submitted to Department of Environmental Protection. So before the DEP received the aggregation plan, which does not specify the installation of fast systems, David Mason had signed off on it. It specifically states that the 5.1 acre credit land was sufficient to address the denser development. So in other words, the 85 bedrooms or the 31 units on 15 plus acres of land, that credit land was sufficient according to.
You're not sure where that is in the record? Or do you know?
It would be in the first volume. Let's see if I can pull it up.
I mean, the first volume doesn't have anything in the summary judgment record. It's the answer and the complaint.
If I could get back.
All right. Attorney Madden has frozen screen, which has been happening throughout. I don't know if you can hear us, Attorney Madden, but we're going to take a break here. It may be better to go with a phone call to you where your screen keeps freezing and audio interrupts. If you have no objection, I'll have the clerk call you and see if we can patch in just the audio portion. That might work better. Any other suggestions by the judges?
That's a good idea. I think the record reflects she's got about 6 minutes left.
Okay.
Ultimately, David Mason did eventually acknowledge that it wasn't a requirement, it was that they approved it, which is precisely what the DEP had stated back in 2006 when further inquiry was made about whether or not they were actually required. Irrespective of that. Oh, I'm sorry.
Where did he acknowledge that it wasn't required?
When he, in response to his request for admissions, what was specifically asked about requirements by the DEP to install the fast systems, he did not specifically state that they were required. He merely stated they were approved. So he sort of backed out of what he had previously insisted on over the course of several years, was that the DEP required. But even if the DEP did require some of the installation of those fast systems, it didn't pertain to Ms. Daly's property because she was not under contract to have it installed. The developer was required by law to give her notice and record the notice of alternative sewage disposal system with the Registry of Deeds. That was not done. So even putting aside that the DEP did not specifically require the fast systems, the fast system should not have been installed on Ms. Daly's property in any event, which David Mason was made aware of after Ms. Daly purchased the property. In fact, my brother even concedes in his brief at page 15 that shortly after her purchase, Daly discovered that McShane had installed an alternate denitrification septic system or fast system on the property instead of a standard Title V system, and then that she sought to have the system removed. And that Title V system, again, was what was approved by the planning board in response to the developer's comprehensive permit application. But the other concern as it pertained to the fast system is that currently, well, Ms. Daly has since sold her property, but the other 5 homeowners were allowed to turn their fast systems off. Now, defendants also do.
Counsel, where is the record support for that?
That is acknowledged in David Mason's deposition transcripts. He's also acknowledged it in the discovery responses, which are included in the record. The town does note that notices were sent out to those 5 property homeowners that that was going back to 2007, that they were obligated to have those septic systems turn on. However, the town has acknowledged that they've got no procedure by which they follow through on whether or not these systems are turned on. And at the time they were installed, they were experimental systems in any event, but there's been no follow-up. The only follow-up that's ever been done in terms of these systems was when the town, or David Mason in particular, required that Ms. Daly remove a bedroom in order to have her fast system removed.
So, Counselor, am I correct in understanding that when you say he allowed others to turn off the fast systems, what you mean is that the town didn't have a system for tracking whether people had turned them on?
They had no system. And in fact, David Mason specifically stated during his deposition testimony that the town had no intention to develop any such procedure, even though the manufacturer and installer of the fast system specifically has stated that they're required to be maintained and they're required to follow through. The law also states that where a town fails to follow through, the DEP itself should follow through to make sure these systems are operating properly. The whole point of them being installed is the nitrogen loading concerns, but if they're turned off, there's no oversight. So the question then becomes, well, why were they installed, number one? And number two, why was Miss Daly required to remove a bedroom in order to have her system, for which there's no contract on file with the Board of Health, removed? And she paid for a 3-bedroom, she had to sell a 2-bedroom, and there was a cost difference in that, and it was a significant cost difference.
Could you explain for me the basis of your due process claim?
The due process claim has to do with the fact that Ms. Daly was denied the right, property rights to the 3-bedroom home that she purchased. Again, there was a higher cost to buying a 3-bedroom home as opposed to a 2-bedroom home, and she was denied.
Are you making a substantive due process claim, a procedural due process claim, or a claim of equal protection violation?
Well, substantive and equal protection. I mean, for the sole purpose of the fact that she, and again, not disputed by the town, that she's the only single woman living by herself, or was the only single woman living by herself in that 40B development that was required to remove a bedroom in order to have the fast system removed, even though the town was on notice and very well aware of the fact that there was no contract on file for the installation of that system, and that she wasn't made aware of it until after she closed on the property. She was never given an option to have that even just turned off, as the other property owners subsequently did. But
I just point out you have 30 seconds left.
Okay. Other than that, unless the panel has any further questions, I would rely on my brief, and I appreciate the panel's attention.
I have one more question. What theory of civil conspiracy are you advancing? Are you advancing the underlying tort theory or the coercion theory?
Well, it's actually a little bit of both. I would say both would apply, but certainly there was coercion because it was the only way Ms. Daly was allowed to remove the fast system, but it's also multi-level in terms of the removal of the moderate deed restriction. So.
Okay. Thank you. Thank you, Ms. Madden. Attorney Barnett, we'll start your 15 minutes now. I'll let you know when you're down to 5 and then to 1.
Members of the panel, may it please the court. I represent the defendants, the town of Sandwich, and several former and current town officials here. I want to touch base on a couple of things that my sister brought up. One, she says that the fast system, which she spoke at length, was wrongfully installed. And the reason she gave is because there was no maintenance contract to it. That's because Mrs. Daly wouldn't sign a maintenance contract, Your Honor. The record clearly shows that it was not wrongfully installed. And if it was wrongfully installed, it was because Mr. McShane decided to install it on that lot. It had nothing to do with any conduct of the town or David Mason. And she hasn't offered anything in the record that would show that Mr. Mason knew it was wrongfully installed. In fact, Mr. Mason's affidavit, which is part of the summary judgment record, I believe it's volume 3 at 79, he he outlines this, and he also attaches a list of the properties, which is stamped on August 20th, 2004. And if you look at that, it says lot 22, and there's a denitrification listing there. So as of before Miss Daly purchased the property, Mr. Mason was aware, or from Mr. McShane, that lot 22 was supposed to receive a denitrification system. If you look even further at the
Council, before you look further, could you tell me where that was?
Sure, Your Honor. That is Mr. Mason's affidavit is volume 3. I believe it's page 79. The pages are difficult to see, and it's exhibit A to volume 3.
As long as we're near the page number. It's
okay. Thank you, Your Honor. The other point I'd make on this issue of wrongful installation, and again, Your Honor, it has nothing to do with anything that the town did. This is what the developer did, and it was Miss Daly, when she became aware of it, she sued the developer. The aggregation plan, which she mentioned, that is recorded with the registry, it also contains the plot plan to this, and I believe that's at volume 2, page 220, Your Honor. Every version everyone's seen of the plot plan is very difficult to read, but it also, what it has is that table that I just referred to in a very small form there. It's difficult to read, but if you count down 22 lines and next to number 22, when this plan was recorded, it listed a denitrification system next to Miss Daly's lot. So the town wasn't aware of any wrongful lot switching or anything of that nature. With regards to the, my sister's focused on this word required, Your Honor, versus approval. And I would submit, and I believe you mentioned the email exchange between Attorney Madden and the DEP during this litigation, which is attached as an exhibit to her amended verified complaint. It states that the DEP did not approve the systems per se, but they were required as part of the aggregation plan approval. But the permitting was done by the Board of Health, as it would be. I want to kind of outline this issue of required. There were no nitrification systems required to develop a 40B project. What happened here is what happens with any project. The developer sought to have more bedrooms than he would have been permitted based upon the calculations under the CMRs. In order to have those additional bedrooms, he proposed 6 of these fast alternative systems, because what the alternative systems allow you to do is increase the nitrates, the 440 gallons per acre that is usually allowed. It goes up to 550. So you don't need, it's typically 4 bedrooms for 40,000 square feet or 10,000 square feet per bedroom. You're allowed to have more. And that's why Miss Daly on her lot was allowed to have more. The fact of the matter is, when she discovered this, and we haven't got into why it wasn't discovered by her due diligence before her closing, that's beside the fact, but when she discovered it, she came to Mr. Mason. And all Mr. Mason did was contact the DEP, because it was a very unique request he had never had. He confirmed with the DEP that if she were to remove this system, she would have to reduce the number of bedrooms because of the count of bedrooms in the development. That's all he did, was pass along that information to her. He wrote a letter to her, and that forms the sole basis of her MICRA claim, her fraud and misrepresentation claim, Your Honor. And I would submit, as Judge Rufo noted in his summary judgment decision, that's not enough here. There's nothing in the record to suggest that he knowingly misled her, that he was even wrong, that anything he said was unlawful. And certainly there's nothing in the record to show that he violated any civil right or attempted to by threats of intimidation or coercion. It's a letter, Your Honor, that he wrote. The plaintiff's own testimony was she felt coerced to do it. and she was intimidated by him because he was tall when he came to her home to just inspect to make sure the bedroom was removed. I would submit, Your Honor, that's not enough.
As Attorney Barnett, this is Justice Lemire. As I understand just the mechanics of this, I'm backtracking just a little bit, but the requirement to go to 2 bedrooms was based on the number of bedrooms in the development, not based on her lot size or her home individually, correct?
I believe that is correct, Your Honor.
Right. Thank you.
So in the original argument I made in my papers is before we even get into the substance of this, Your Honor, is that all of these claims, are barred by the 3-year statute of limitations. We're dealing with a letter that was sent in 2005. Miss Daly then sued Mr. McShane and actually the town in 2008, I believe, when she learned that she would have to undertake this expense.
I didn't see anywhere you raised that in your summary judgment papers.
We don't raise it in our summary judgment papers, Your Honor. It's raised in our motion to dismiss papers. In my argument to that, Your Honor, is that we have raised it below. It's not raised in our summary judgment papers. It was raised and preserved below. We weren't entitled to an interlocutory appeal on that motion to dismiss. And even if we're precluded from raising it now, nothing precludes the court, of course, from deciding it on its own initiative. So I just wanted to point out, Your Honor, that there's no conduct even alleged after Miss Daly removes the system or removes and replaces, which is the next point I'll make, Your Honor. There's nothing alleged in the complaint. The entirety of her efforts are, once she realizes she did this, she determines this may have not been a good deal or a good idea because I may lose money on this if I ever go to sell this as a 2-bedroom. So I'm going to ask the town, with Mr. McShane's help as part of the settlement with him, if they would remove the moderate deed restriction, because there is a restriction on the property as to how much she can sell it because she bought it as a moderately priced unit. Her claims with regards to that were voluntarily dismissed, Your Honor, and I would say that everything else with regards to the MICRA claim, the civil conspiracy claim, and the due process claim, it only concerns conduct that occurred back in 2005. Her claim against Mr. Mason is with regards to a letter in a meeting in 2005. Her claim for any civil conspiracy or for any due process violation goes back to that same set of events. It doesn't concern anything after that. A couple other points I'd like to pick up on, Your Honor. There's an allegation that Mr. Mason misled her because he told her she had to remove and replace the FAST system. The fact of the matter is, he used those words, but what he meant, what he testified to and what's in the record is this is a tank that was underground, and when they opened it up, they realized it could be retrofitted and done easier to be made a more compliant system. So it's a red herring to say that Mr. Mason misled them because they physically didn't have to take out the entire tank and put a new one in. Parts had to be changed on this one. I don't think that's enough to say that he misrepresented or was fraudulent in this case.
You're at 5 minutes.
Thank you, Your Honor. On the due process claim, I'd argue that it's duplicative of her MICRA claim, the claim that's set forth under Article 11. Our position, Your Honor, is that there's no private right of action to bring a claim for a direct violation under the article. That is what the Mass Civil Rights Act, the remedial scheme for that is permits. And
Hold on 1 second, Mr. Barnett. I noticed that hold on 1 second. The clock is at 14 minutes. We were at 5 minutes just a short time ago. So thank you. Go right ahead, Mr. Barnett. We just reset the clock for 5.
Thank you, Your Honor. Ms. Daly can't circumvent the remedial scheme of the Massachusetts Civil Rights Act and the requirements of threats, intimidation, coercion by simply pleading a due process claim under Article 11, Your Honor. She brings it against each of the defendants, she states. You can't have a Massachusetts Civil Rights Act claim against the municipality under the Howcroft case, and she's pled nothing whatsoever as to any of the other defendants other than Mr. Mason. In her complaint, she only alleges a due process claim. I understand, and we've addressed it in our papers, the equal protection argument that's been made that Judge Rufo had addressed. I would state, Your Honor, that there is no, she's not pointing to similarly situated people in this matter because nobody else, the difference here is nobody else requested the removal of their system. She's stating that she was the only single woman who was required to remove it. The fact of the matter is nobody requested it. And the record shows that from the town's records, there were 3 other property owners on file, all of whom Attorney Madden represented in the suit against Mr. McShane, who the town understood were female homeowners. Unmarried, they were the only listed people. And we've addressed that in our papers. So she hasn't set forth any evidence whatsoever that she was treated differently than anyone else similarly situated, Your Honor. The last thing I would mention, Your Honor, is the civil conspiracy claim. There's nothing in the record to suggest that or any evidence whatsoever that any of the defendants, Mr. Mason included, but certainly Mr. Dunham, Mr. Lapp, Mr. Haney, and Mr. Van Buskirk had anything to do with any of the allegations that the plaintiff has set forth. Her entire complaint is based upon her subjective beliefs, her conclusory allegations, and her own testimony, much of which she simply states, I rely on my complaint or I do not recall when asked about these things. And I would submit, Your Honor, that those responses, which are contained in the statement of facts that she says Judge Rufo ignored or misstated, first of all, they're not evidence that would preclude summary judgment, and they do not raise a genuine dispute here. Judge Rufo considered these facts. He explicitly rejected them. He actually criticized them, Your Honor. And much of them are simply plaintiff's interpretation as what she believed to have happened. And that's not enough here, Your Honor. If the court has no further questions, I'll rest on my papers.
All right, you have 1:45, but any questions of the panel? I see no questions. So thank you to both counsel. The case has been submitted. So try to make references to the initials or whatever is convenient. We will start with the argument, Ms. Levinson.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. I am Lori Levinson and I represent the appellant CT. The law and the facts of this case compel this court to vacate the restraining order that was issued by the court below because the court below should never have issued an order under 209A based on the lack of evidence that was presented at the hearing for the lower court. I respectfully submit that RT did not prove by a preponderance or even by a scintilla of evidence that there had been any abuse whatsoever in the past, either sexual or physical. As to
the corroboration requirement, that her testimony and her affidavit alone aren't enough?
No, Your Honor, they would be if there is any substance to her allegations in her testimony and her allegations, but her allegations, both in the affidavit and in her live testimony, were completely devoid of any kind of explanation, particularly as to the physical allegations of physical abuse. She never mentioned one detail that would have constituted what anybody might consider to be physical abuse. She just baldly stated, my brother physically abused me, with absolutely no details about anything that we could have possibly imagined. What was this alleged
Isn't that
physical?
one of cross-examination? Weren't you entitled to ask her, well, what do you mean he sexually assaulted me? What do you mean he physically abused me?
Well, Your Honor, yes, I certainly could have in my cross-examination. However, her direct examination was devoid of any facts, and I certainly didn't want to create a record that could have potentially brought forth evidence that was missing from her own testimony. Now, she did allege certain facts as to sexual abuse, but those were only alleged in her affidavit. She never said one word about sexual abuse in her live testimony. And what is so interesting, I think, about that is that the court below, in his written findings of fact, at paragraph 3, incredibly found that, and I'm quoting, the plaintiff testified at the hearing that the defendant, her brother, had repeatedly sexually assaulted her. But if you look at the transcript, she never mentioned that at all. The only reference to the sexual assault appeared in her affidavit, in which she described a sexual assault as being, quote, forcing her brother and her to watch pornography, and then making her get into sexual positions. We don't know, where was the force, where was the threat, where was the duress, and most importantly, where was the sexual relations? Because Chapter 209A, Section C, which is what the court below was looking at here, defines sexual abuse as causing another to engage involuntarily in sexual relations by force, threat, or duress. Now, sexual relations are not defined in 209A, but even without reference to any other statutes, which I will go on to, but even without reference to other statutes that define sexual relations, common sense dictates that sexual relations means more than sitting on a couch and watching pornography. And we don't even know what kind of pornography, where they were. We know nothing, just this bold allegation. That cannot possibly rise to the level of a preponderance of the evidence that a sexual assault, that CT caused RT to engage involuntarily in sexual relations. There's also the only reference to force, threat, or duress was her bald statement, again, only in her affidavit, not in her live testimony.
Counsel, can't we infer force from the age difference between them?
There was, I believe, a 4-year age difference, Your Honor. Both were minors at the time. So it's not as if it's an adult forcing a minor who doesn't have the capacity to consent.
But he's the older one. He's 4 years older.
Yes, absolutely.
So doesn't that add to some evidence of force?
It certainly could add to some evidence, clearly, but not preponderance of the evidence that he did anything to force her. What did force mean? Was it just saying, come on, RT, sit next to me and watch? We don't know.
Counselor, how do we know you made any of these arguments in your motion to vacate?
Excuse me, I'm not sure I understood your question.
How do I know you made any of these arguments in your motion to vacate?
My motion to vacate should be a part of the record assembled by the court below.
Well, there's a procedural issue here. The notice of appeal that I understand you filed was from the motion to vacate, the denial of the motion to vacate. You didn't file a notice of appeal from the issuance of the restraining order. Is that correct?
If I did not, Your Honor, that was certainly a procedural oversight on my behalf, because my intent certainly is to vacate the restraining order, and that is what I've asked this court to do.
Do we have before us the transcript of the hearing on the motion to vacate?
No, we don't. We only have the transcript of the hearing on the restraining order.
So you understand Judge Ditkoff's question as to how do we, whether that was argued in the motion to vacate, which is what is under appeal, the motion to vacate.
I do understand, Your Honor, although my intent, and as I set forth in my 2 briefs submitted to this court, what we are seeking is a vacation of the restraining order because it was issued absent any evidence of abuse. And so we just have a completely improvidently issued order here.
Is there any time limit on how long after the issuance of the restraining order you had to file a motion to vacate?
I believe under Rule 60B, it would have been within a reasonable time. And of course, I did file that motion within a very reasonable time. I believe it was within 7 days of the issuance of the order, if not sooner. It didn't get heard right away because the first judge that it came before was not the issuing judge, and she declined to hear it and punted it back over to the judge who actually issued the restraining order. So it took a little extra time to get heard, but the request was made in a timely manner. But I don't believe that I was restricted to a particular time frame.
Go ahead, counsel.
Okay. Then not only do we have the fact that this order of protection was granted absent a preponderance of the evidence that there was any abuse, sexual or physical, I know that my sister will certainly be arguing that under Callahan versus Callahan, which appears at 85 Mass Appellate Court 369, the order was correctly issued because when a request for an order based on past abuse is requested, the plaintiff need not show a reasonable fear of imminent physical harm. And that is true. However, under Callahan, that does not end the court's inquiry. Even if there is not a reasonable fear of imminent physical harm, which I certainly submit is not the case in this case, the court is instructed by Callahan to not just issue an order based on past abuse alone, but to also, and very importantly, evaluate the risk of harm to a plaintiff if an order were not to issue. And in this case, there was nothing submitted to the court that could have led him to believe that the plaintiff there faced any risk of harm whatsoever. By the time the restraining order came on for hearing, and in fact, before the application for a restraining order had even been filed, CT had moved out of the Commonwealth of Massachusetts.
He showed up at the restaurant where she worked, and she had to go to her boss and asked to be moved to a different room because she was so upset. Isn't that a risk of harm?
No, Your Honor, and I'll tell you why. Because he was sitting there, he did not know that she worked there, as she actually conceded in her oral testimony, that he didn't know that she worked there. He saw her, she saw him. They apparently met eyes because she says he looked at me with disgust and anger. And then she left that area, never to lay eyes on him again. And then,
well, isn't that evidence of the harm to her then?
Well, she did testify that she felt traumatized by having seen him, but excuse me, she sees him, she goes to another room, doesn't see him again. Months pass before she even applies for a restraining order. And in those intervening months, there is no contact, no attempted contact. He has relocated to the state of Georgia. There were no attempts at contacting via social media or any other method at all.
Why do you say that? The testimony was there were. He's been trying to contact me through calling and social media, adding me, Facebook and Instagram. He's done this for the past couple months.
Correct, but that was after the alleged, well, not alleged, after the chance meeting in the restaurant. I don't believe that there were any contacts at all. And certainly once the hearing ended, there's never been any contact, but of course there was a restraining order issued.
Well, how do you distinguish Yana Y versus Sylvester S?
Okay, so in that case, Your Honor, let me just grab my notes on that case. In that case, I believe that, yes, that's where the plaintiff had gone off to college, and then her alleged abuser found her on campus and was harassing her, and the court found that he was aggressively pursuing her, and so she remained in reasonable fear. So that case showed an aggressive pursuit, which would cause her to remain in fear. In this case, the only face-to-face contact in a 2-year period was a chance meeting at a restaurant.
It says he was not a student at UMass Amherst, but he approached her in a dining hall. The sight of him made her freeze, then flee. She no longer felt safe on campus. So how is that any different from the facts here? Are you saying that's more aggressive than showing up in the restaurant where she works and she can't leave because she's working?
Well, yes, Your Honor, because she did leave the presence. She was allowed to go into another room, and then he moved to Georgia. So right after that, there's no more possible threat of bumping into each other or anything of that nature. So that is different. And he was not pursuing her. He wasn't aggressively pursuing, which was the fact in Yana versus Sylvester. The court specifically used the language aggressive pursuit. Here, there was no pursuit at all. CT did not pursue her in the restaurant. He went to eat with his grandparents and a cousin.
Could the judge have inferred from her affidavit and the fact that the CT showed up at the restaurant with his grandparents, that the grandparents told CT that she worked there, or the grandparents brought CT there on purpose to try to effectuate some kind of a reconciliation?
Well, that's certainly not even close to a compelling inference at all. It's really blatant speculation, particularly when RT specifically testified in her oral testimony that CT did not know that she worked there.
But her grandparents did.
But the grandparents did. Yes, but then we didn't have any evidence of CT trying to initiate contact with her. He didn't get up from his seat and try to walk toward her, to pursue her, to talk to her. He did nothing.
I have one more question. Sure. Are you withdrawing your argument about the firearms surrender issue?
Yes, Your Honor, because at the extension hearing, the court that extended the order noted that she did not have personal jurisdiction to order the surrender of firearms in the state of Georgia. And so I believe that that renders that claim moot. Because a permanent order based on the initial improvidently issued order then followed. So I would, of course, argue that the initial order should fail. And then, of course, the extension of the order should also be vacated because it was based on the initial order.
So I
So I
don't
do believe
understand,
that's
are you
moot.
asking us to vacate the firearms provision or not?
Well, I think that it's moot, but if it's not moot, then I certainly am asking you to vacate it because the court never had jurisdiction over that subject matter. It had personal jurisdiction over CT, but it did not retain, does not have jurisdiction to order another state to have him surrender his firearms.
Could the judge have issued a 209A that said to your client, if you come into Massachusetts, you're forbidden from possessing any firearms?
Yes, I believe he could have.
Why didn't you have to raise this at the hearing?
Your Honor, I frankly didn't know that when the judge announced that he was issuing an order, nothing about the firearm provision was mentioned. There was no mention of it in the hearing. There was no mention of it in the affidavit. And so it took my review of the restraining order to see that that box was checked off. And as soon as I noticed that, I noted the personal jurisdiction issue.
Any further questions? All right. Thank you, counsel.
Thank you very much.
Attorney Dunn.
Good morning. May it please the court. Ann Dunn on behalf of Plaintiff Appellee RT. As an initial matter, as this panel has already noted, before I approach the merits of this case, there are a number of procedural errors that are fatal to CT's appeal. First, he failed to comply with the rules of appellate procedure, specifically Rule 18 in assembling and preparing the record appendix. He did not provide the court with a complete record. He failed to provide the complaint, the transcripts from the August 7th, August 23rd, and September 17th hearings, and additionally failed to provide the August 7th, 2019 abuse prevention order, which counsel claims to be appealing here, although the notice of appeal does not indicate that that order has been appealed. Additionally, despite numerous citations to the August 7th hearing transcript, it is not contained in the appendix. In support of Appellee's brief, I filed requested leave from this court to file a supplemental appendix and did so. In that supplemental appendix, I included a copy of the transcript. In his reply, CT argues that his flagrant disregard for the appellate rules should not be fatal to his appeal because RT provided this court with the supplemental appendix, including the hearing transcript, and therefore filled in the gaps that he had left. This argument is nonsense. Second, in his reply brief, CT impermissibly seeks to address matters outside the record, advance new arguments, and seek vacatur of an order not properly before this court. It's well settled under this court's precedent that new issues cannot be raised for the first time in a reply brief. Indeed, this court has held that issues raised in a reply brief come too late. Fundamentally, CT cannot advance arguments relating to the August 11th, 2020 order, which was a permanent extension of the initial order, because he failed to notice an appeal from the issuance of that order. The August 11th, 2020 order is not contained in the record before this court, and this court lacks the authority to vacate that permanent order as requested by CT. Turning to the merits of this appeal, CT has made a number of tactical errors throughout the matter. The most notable of these errors being his failure to appear at the August 7th, 2019 hearing, despite receiving notice. CT argues that he made a judgment call to not appear based on his review of the affidavit presented in support of the complaint. He waived his appearance through counsel, failed to argue that the court lacked personal jurisdiction over him. Lack of personal jurisdiction is waivable, and it was waived here. CT first raised the personal jurisdiction issue after the hearing was complete and the order issued. In addition to making the decision not to appear himself, CT decided not to call any witnesses on his behalf or provide any evidence to rebut the testimony provided by RT. CT had the right and ability to call witnesses in support of his claims, but he did not. In support of her complaint, RT provided an affidavit. In that affidavit, she unequivocally stated under the penalties of perjury that her brother had both physically and sexually abused her for a number of years as a child. With respect to the sexual abuse, RT stated that she was abused for 3 years. Notably, and despite Attorney Levinson's argument to the contrary, RT specifically stated in her affidavit, he forced my brother and I to watch porn together, which he then would make me, that's force, get into the sexual positions as he claimed to be teaching me how to please a boy right. That is sexual abuse. Bar none, no dispute. Making a child under the age of 11 get into a sexual position so you can teach them how to please a boy right is sexual abuse. The sexual abuse continued until she was 11, and the physical abuse continued until she was 13. When RT turned 14, she told her mother about the abuse she had suffered at her brother's hands, and her mother decided to do nothing to protect her. When RT turned 18, she sought a protective order on her own from the district court. And yes, it was several years after the abuse had occurred, but it was when she turned 18.
Counselor, the judge wrote that the totality of the circumstances reasonably put the plaintiff in fear of imminent serious physical harm. Are we bound to affirm or not affirm on that basis? And if not, why not?
No, you're not bound to affirm or not affirm on that basis. Obviously, the district court's determination is afforded deference by this court under your precedent because he was there and observed the parties, or in this case, only RT since CT did not appear at the hearing. But we don't even need to go to imminent reasonable harm because the judge found that RT suffered years of repeated sexual and physical abuse, and that abuse was so traumatic that the passage of time did not mitigate RT's fear of CT. She presented evidence that the abuse left lasting physical and psychological scars.
Counselor, where did the judge find that you just said?
One moment. The judge specifically held in the decision in paragraph 3. I also note that at the hearing, the plaintiff appeared upset, distraught, fearful, and clearly still affected by the defendant's prior sexual misconduct.
Thank you.
During the hearing before the trial court, RT was crying. That's not evident from the transcript, but she was visibly upset, shaking and sobbing during the exam from the court and CT's cross-examination of her. And even if RT needed to establish reasonable fear of imminent harm, she has done that here, and the lower court found that. The trial court did not use its discretion in holding that the totality of the circumstances reasonably put RT in fear of serious physical harm. RT testified that CT had been attempting to contact her with increasing frequency by phone and social media, and he appeared at her workplace. While he was there, he did not leave when he saw her. He stayed. He sat down and he ate a meal. During that meal, he glared at RT, looked at her with disgust. All the while, RT was continuing to try to work while suffering a panic attack. Additionally, my sister counsel argued that RT had testified that after CT appeared in the restaurant, there were no more contact attempts. It is not clear from the transcript that that is what occurred at all. Rather, RT testified that although I asked for no contact, he still did not stop. For the past couple of months, he has still tried for the past year as well. The judge asked her if he was trying to contact her indirectly through social media, and she responded, yep. She said he was trying to contact her through both Facebook and Instagram and other social media platforms that she uses. He's also tried to use his family to contact her. And while my sister counsel argued that there is no possibility that RT and CT will see each other because he now lives in Georgia, she fails to mention that they are brother and sister. They have the same mother. They have the same siblings. Indeed, during high school, RT actually moved out of the family home on her own when her mother allowed CT to move home. She was a minor and she left her home because she was so fearful of living under the same roof as CT based on the years of abuse she suffered at his hands, both physical and sexual abuse. This case is clear that RT has suffered abuse at the hands of CT. That abuse has left long-standing scars, both physical and psychological scars, and she needs protection from her abuser. Protection that her family was unable or unwilling to give her. She's come to the Massachusetts judicial system to get that protection, and she has obtained an order. And CT now seeks to have that order vacated, despite not appealing either the initial order, the August 7th order of 2019, or the August 11th order of 2020.
Counsel, what do you say in response to your sister's argument that the lack of a criminal prosecution shows that your client's allegations are less credible?
I would say she's wrong. My client is a young woman. She's scared. She does not want to have contact with her brother. She doesn't want to have to prosecute him to serve as a witness there. She's obtained this abuse prevention order. She's not obligated to seek criminal charges against him in order to have this restraining order. That's well established. 209A does not have a requirement that you must also seek to have charges filed against the abuser. It's just not in the law.
Thank you.
I have nothing further.
All right. No further questions from the panel. I see no further questions from the panel. Thank you very much. The case has been argued. It's under advisement. We appreciate your arguments. Thank you.
Thank you.
All right, we are live and recording.
All right, good morning. I think it's still morning. This is the matter of consolidated cases of docket number 2020P 319 and 2020P 320. The 319 is Canatal Steel versus TLT Construction and others. And 320 is Barker Steel versus Montezut Regional Transit Authority and others. Attorney Conti, go right ahead.
Good morning, Your Honor. Thank you. Your Honor, throughout this presentation, I will refer to Montezut Regional Transit Authority as MART. Your Honor, here we have an abuse of discretion by the lower court judge. The reason it's abuse of discretion is because a motion to amend, which is at issue, should be allowed unless there is a good reason not to grant the amendment. Now, the judge relied expressly on the papers submitted by Western, the opposition by Western. That opposition said that there was prejudice, that there was delay, futility, and dilatory conduct. It didn't proceed in its papers on appeal with respect to dilatory conduct, which is another way of saying delay. With respect to prejudice, there's no prejudice here. In fact, all you have to do is look at the brief of Western to see that. They don't even argue it. They don't even argue the opposition to the motion to amend until the 21st page of their brief. But they don't articulate actual prejudice, which is the standard. You have to show actual prejudice. And there is no prejudice here because these parties were present at inception of this matter way back in 2013. It was the same surety company, the same regional transit authority, the same contractor, TLT. No surprises, no prejudice. The parties reserve their rights expressly in an agreement to pay the surety the full sum under the performance bond. The balance of the contract, this was approximately an $8 million contract for the construction of a commuter rail garage in Leominster, Massachusetts. So follow that through. The surety expressly reserves its rights. MART expressly reserves its rights. This is in 2014. The surety makes clear that MART puts aside $5,000, which it is still holding in escrow, so that the surety can reserve its rights also. My point in pointing out what the surety did, because that was the modus operandi throughout this, is that if TLT had been successful on its claims in the underlying arbitration, it was asserting $1.4 million claims against MART. If it had been successful, TLT was no longer functioning as a going concern. As of August of 2013, that's what we found out in the arbitration. MART was, so the point is, Western was going to proceed on those claims. It was, if it had received a favorable arbitration award from Judge Hinkle, the surety was going to proceed against MART. That's why when it talks about house cleaning now, that's all revisionist history, Your Honors. It was going to proceed against MART to collect on those claims. So now when MART attempted to, sorry, Your Honor?
You'd probably be here telling us they shouldn't be allowed to amend in that way.
Except, Your Honor, I think the issue is, would I have a good reason? Could I claim that MART was prejudiced in any way? And the answer is no. I think that crystallizes.
Counselor, could you walk me through the 3 counts that you want to raise in the amended complaint? I read it, but I wasn't really following those. If you could really tell me the essence of them, that would be really helpful.
Yes, Your Honor. There were 3 claims in the motion to amend, but we're only at issue. The only one at issue in this proceeding is the breach of contract claim with respect to the payment bond. That's it. The 93A claims don't need relation back. There's no issue. Those have already been made in Worcester Superior Court. Those relate to the arbitration, which was in 2018. Does that answer your question, Your Honor?
That's very helpful. Could you explain a little more how the professional fees, owner representative fees, statutory interest? Could you explain how that works? What that claim is for?
So that claim, Your Honor, again, it's under the performance bond. So by statute in Massachusetts, for a public construction project of this size, the general contractor, TLT Construction, had to provide performance and payment bonds. That's what it did from its surety, Western Surety Company. It's the same bond number for both. So the claim is very specific against Western Surety. It's for Section 7 of the payment bond. And that provides that because we won the arbitration, so in other words, MART arbitrated against TLT before retired Judge Margaret Henkel. She was the arbitrator. She found and awarded in favor of MART. MART prevailed. We received a decision where MART was awarded, I believe, $214,000. She also found, this is the key point, she found that it was TLT that materially breached the party's underlying contract. As a result, going back now to the performance bond, section 7, because of that breach, the surety is on the hook for legal fees and professional fees resulting from the breach of its principal, TLT, as found in the arbitration award. That's the case. It's that narrow. There's not a lot of discovery to do. It's very minimal. In fact, the case is so narrow, all it requires is the introduction of the arbitration award, the language of the bond, which is a matter for the court, and it's already been interpreted by other courts out of jurisdiction. We can collect on this if the court gives us relation back. And further, the legal fees, the invoices for the legal and professional fees, and Mart's verification of payment. That's it. That's the case. That we're looking for relief from the appeals court today.
All right, so you've suggested they haven't argued any prejudice, but they did argue futility, and they suggest that there is a contracted statute of limitations of 2 years. What do you say to that? What do you say to that?
Yes, Your Honor. So these original cases were filed in the fall of 2013 by subcontractors. So one was Canatel Steel, the other was Barker Steel. Now, both of those cases, both Mart and Western Surety are parties to those cases. Were parties to those cases back in 2013. The project was not even finally completed until 2015. Now, what we've alleged all along in our amendment as well as in our brief is that we're entitled to relation back based on Massachusetts law. So the date for the case is 2013. So that takes care of any claims by TLT that aspect of the case is futile because of this shortened statute of limitations if we were to get relation back. And we're entitled to relation back under the law. Now, what also we're saying, though, in our reply brief, which I think Western misunderstood, is we're not making a new argument with respect to that Section 11 in the performance bond is actually a private statute of repose, not a statute of limitations. What we're saying is that if the court were to look at that, it is a private statute of repose, and it should be invalidated. And we were making the point that if it were invalidated, we wouldn't even need relation back because we would have filed the original amendment within the 6-year statute of limitations or statute of repose under Massachusetts law. Hopefully that makes sense.
Well, I understand the argument, but you agree that you can contract for a shorter statute of limitations. You agree with that concept?
Absolutely, Your Honor.
Is it your suggestion that because this is too broad, that it acts as a statute of repose?
Yes, Your Honor. And just so we're clear, I'm not saying that obviates the argument of relation back. There are two different arguments. One is we're entitled to relation back. The second, the extension, is that if the court really looks at this, you can have a shortened statute of limitations in Massachusetts, absolutely, but it has to be governed by the discovery rule. And this in the bond is not. It's a bright line. And only the legislature can do that in Massachusetts. You can't have a private statute of repose. And that's what this is. Now, Your Honor, so the other argument on futility, the flip side of that, which I was speaking about earlier, I want to loop these together, is the merits. So Western never discusses the merits because it knows it's on the hook. It knows it's on the hook under the bond, under what transpired, and under the finding of the arbitrator. The arbitrator found that its principal materially breached after all these years of claiming it was entitled to approximately $1.4 million in claims. So this is the opportunity for Mart to recoup all of these taxpayer monies spent on all of these costs resulting from TLT's breach. TLT is the principal of Western. And then, Your Honor, the last point I would raise is delay. The case law is clear on this. TLT is about, Western's brief is about sound bites. 6 years of delay. That's what it said in its opposition below. That doesn't hold up. We have outlined exactly what the delay was. This was a very, very complex case, as Your Honors can see. The timeline was that all these parties were aware of what was going on. They were fully involved. In fact, even in the arbitration, although the initial arbitrator, Judge Van Gastel, had excluded Western from the case, Western immediately put its own counsel, who is appearing today, in charge of the arbitration as lead counsel and paid for that. Western, and not only that, during the arbitration, Western's principal bond counsel, who's been on this case since day one, appeared without subpoena from Chicago, CNA, and testified on behalf of the principal. I mean, Western has been involved in this, intimately involved with this case all throughout. And to claim that there was delay or prejudice, it participated in both mediations with a professional mediator. There's no delay. Unfortunately, this is how a lot of these complex construction cases proceed for whatever reason. We don't make any excuses for that. We're just saying that's what it is. And we wanted to settle at every turn, if possible. That's what would benefit the Commonwealth, if possible. That wasn't possible. And so now what we're saying is, here we're entitled to relation back. There was no good reason. Mere delay, that is not enough. Even if there were a delay, it's not enough. And we're saying the surety was on notice of this bond all along. It's its own agreement. It knows what the agreement is. And this motion to amend should be granted. We should be allowed to proceed on these claims. Thank you.
Counsel, I have a question on that. I understood in your introduction that you were saying it was an abuse of discretion for Judge Henry to deny the motion to amend because he didn't have a good reason not to allow it. Is that the standard for abuse of discretion under LL v. Commonwealth?
Well, LL v. Commonwealth talks about that. In that case, it talks about the judge making a clear error of judgment and weighing factors relevant to the decision. But I think, Your Honor, I respectfully ask you to look at the Afarian case, which I cite, which is 449 Mass 257 269 2007. And I think what you'll find in that case is that, and I quote, the express tendency is in favor of allowing amendments, and a motion to amend should be allowed unless some good reason appears for denying it. And I think, if you look at the Castellucci case, because that's Castellucci v. U.S. Fidelity and Guarantee Company, 372 Mass 288 289 1977. My point there is, in that case, the amendment was not allowed, but it was during trial. Here, we didn't even have a trial day. And I think you're hard pressed to find any case like ours where there was no trial date. We had a stay on. We reported diligently back to the Superior Court and told the Superior Court that our claims were not resolved vis-a-vis Western, and Western signed off on that motion. That's in our papers, a joint motion. But my point is just that, you know, we reported diligently back and moved to amend at that time. The cases were still active. We had just come out of the arbitration. And again, no trial date.
Thank you.
Thank you.
All right. Thank you, Mr. Conti. Ms. Chambers,
You're on mute.
you're on mute.
Unmute. Am I unmuted now?
Yep, you're all set.
Thank you, Your Honors. May it please the court. I represent Western Surety Company as the appellee in this case. And thank you for your time today. Western presents two arguments. The first is a threshold issue as to whether the trial court properly confirmed the arbitration award and properly entered judgment in conformity with Massachusetts law 251, section 11 and 14, thereby closing the case, and any post-arbitration motions, such as the motion to amend to assert cross claims, were properly denied by the trial court for lack of jurisdiction. The second and alternative argument is that the trial judge did not abuse its discretion in denial of Mart's post-arbitration award Rule 15 motion to amend its answer to assert third-party, to TLT's third-party complaint to assert cross claims against Western as surety for TLT's breach of contract under the performance bond and violations of 93A 176D arising from the arbitration in 2018. Mart's attempt to amend its answers to TLT's counterclaims to assert cross claims against Western in 2018 on settled claims post-arbitration is procedurally deficient. And in this instance, Mart did not raise the lower court's jurisdiction prerequisite in its appellate brief. Mart, as a third-party defendant, filed the motion to confirm the arbitration award, but failed to identify what the appropriate statute and grant of authority was for the lower court to enter judgment from the final award.
But judgment never entered until well after the motion to amend had been filed and denied.
The final judgment from the award did not enter until either July or November. It was entered, seemed to have been entered twice, but the judge,
as I understand this, there was general litigation pending. This was not an arbitration that came back post-arbitration to just affirm the judgment of the arbitrator. This was pending litigation that then by motion moved to arbitration as a result of the contractual issues that were involved. The arbitration that left the pending litigation stayed. So there were multiple issues in the litigation that went to arbitration. And when it came back, Mart moved to confirm the arbitration award, but is it your position that terminates any further action on that litigation that had been pending?
It does, Your Honor, because there was nothing remaining pending to be adjudicated.
All right, but procedurally, at least on the docket that I've looked at, judgment had not entered when Mart filed their motion to amend. There was no final judgment. They didn't have to move to vacate judgment. There was no judgment that was entered on the docket. Is that correct?
Yes, but there was a motion to stay that was granted to go to arbitration. Once the motion to stay was allowed to go to arbitration, the case is stayed. Once the case is adjudicated in arbitration, under 251, section 14, then the trial judge has to confirm or not confirm the award. In this case, he confirmed it, and then from the award enters judgment in conformity with that award under chapter 250,
Correct,
section
but
14.
that procedurally had not happened.
Once the award was confirmed in January of 2019, the only.
But judgment wasn't entered on the docket. So the case is still open.
There was nothing left to be decided, Your Honor. The third party complaints were the only claims to be resolved in the arbitration. Cannatel Steel's claim had been settled during mediation. It was certainly a fact known to Mart. Barker Steel's claim had been settled and dismissed. There were no other claims pending. The only claim against Western as the surety was a payment bond claim, with the payment bond claims from Barker Steel as well as Cannatel Steel. So once those claims were resolved, the third party complaints was the breach of contract claim, was the 93A with respect to TL2.
And so you're just saying procedurally, once the judge allowed the confirmation of the arbitration award on the papers, even though judgment had not entered by the clerk's office, that they were not allowed to file any further motions to amend the complaint.
Yes, Your Honor.
All right. I understand the argument.
Okay, thank you. And actually, so in this case, Your Honor, after the confirmation, Mart moved to then file its third party complaints.
I understand, but there was other housekeeping things going on that case before judgment finally entered, which was months later. And in my mind, until judgment enters, the case isn't closed. What closes that case? Just the order confirming the award of the arbitrator?
What closes the case is once the arbitration award is confirmed by the court, by the judge, which was in January of 2019, then the case is to be closed. And
do you have any best authority for that?
The authority comes from 251.
Well, 251 allows somebody to, you don't even have to confirm an arbitration award through with the court. It gives the winning party the opportunity to receive a judgment to maybe enforce a judgment. Isn't that the purpose of 251?
No, the purpose of 251 is, once it's confirmed, is so the winning party in an arbitration can proceed to collect on the award, which has now been reduced to a final judgment.
Right, but you don't need the final judgment to collect on the award theoretically, but as a safeguard, you want to get the judgment so in case you have to enforce it, you have it.
But Your Honor, once the trial case has been stayed for arbitration, once the case is stayed, then under the statute 251, section 14, the judgment enters in conformity with that statute. There was no other claims to be adjudicated in the case. Otherwise, the case doesn't end. That the case, this trial court case, would stay stale on the docket, for lack of a better term.
All right.
So the second alternative argument, Your Honor, is that the trial judge did not abuse his discretion in denying the post Rule 15 motion. And with respect to the Rule 15 motion, Your Honor, Weston doesn't disagree that a Rule 15 motion for a claim on the performance guard could relate back in certain circumstances. The issue is not the Rule 15 motion. Again, dispositively, the issue is the court lacked jurisdiction to grant the motion to amend because the case was stayed for arbitration, confirmed. Once confirmed, the court could only enter judgment in conformity with the award and close the case. That said, procedurally, while relation back is liberally granted, there's nothing to suggest that it's non-existent. The standard of review for a motion to amend pursuant to Rule 15A is the broad discretion of the trial judge, and the trial judge exercises discretion, and it wasn't an abuse of discretion to do so. Moreover, any of the enumerated factors alone can serve as grounds for a judge to deny a motion to amend. We do not dispute that there's more than one grounds or a fact of denial, but there are no cases that state that there must be more than one factor necessary to deny a motion to a motion to amend. It goes to the broad discretion of the trial judge. Nonetheless, the trial judge certainly justified his denial of Mark's motion for leave by fully incorporating by reference in the order Weston's opposition, which did assert untimely futility and new claims.
Counselor, I thought you just said the claims relate back. So how are they futile?
Well, they don't relate back in this case, Your Honor, because they didn't, and this is key, they didn't exist in 2013.
Right, but your brother just said we can forget all that stuff. He's not interested in the 93A anymore. He's not interested in anything after the project finished anymore. He's only interested in the $214,000 that's from Judge Hinkle's arbitration about what happened in the project completion. So I understand why the 93A stuff doesn't relate back, but your brother says that's out of the case now. So how does the $214,000 not relate back?
The $214,000 doesn't relate back because that was determined by Judge Hinkle in 2018, number one. Mart would have to have had a claim on the performance bond in order to recover those fees. He didn't file a claim under the performance bond. He's trying to get it to relate back to 2013. That being said, there was no claim on the performance bond in 2013. There was no claim on the performance bond as alleged until 2018.
But the bond doesn't say any claim has to be raised. It says any proceeding shall be instituted. The proceeding was instituted within 2 years, and it's about stuff that's covered by the performance bond. So why doesn't it relate back if the judge allows the amendment?
Because there are other obligations as set forth in the bond. Legal proceedings shall be instituted within 2 years after contractor default, or within 2 years after the contractor ceases working, or within 2 years after the surety refuses or fails to perform the obligation under the bond. The failure to perform, allegedly, its obligations under the bond arose in 2018, according to Mart, when Western, allegedly refused to pay the award. So they were new claims in 2018, just as the claim under 93A was new claims in 2018 and cannot relate back under a Rule 15 analysis because they were new claims and didn't exist in 2013.
Okay, so you're saying under your performance bond, if it's established you owe money in the performance bond, but it's established more than 2 years after completion, no one can have to pay you because that is a new claim that arises more than 2 years after completion?
No, Your Honor, this case is dissimilar because he's requesting these fees in 2018, which were adjudicated in 2013. the other issue in this case with the performance bond, Your Honor, which should not be lost on this court, is that Western fully performed under the terms of its performance bond, which goes to the res judicata argument that was not expanded upon in its opposition to the motion to amend. If that makes sense, sure. I just confused the court on that one.
Judge Hinkle didn't adjudicate. She adjudicated that someone owes Mart $214,000. She didn't adjudicate that Western didn't, did she?
No, she adjudicated that TLT owed the $214,000, as well as her adjudicating that TLT was also due a sum of $61,000 and change. So it was not just Mart that was successful in its arbitration. TLT was also successful in presenting its change order claims in arbitration. With respect to Attorney Connie's raising the statute of repose, again, the statute of repose argument was waived. It was never raised in the lower court, and Western certainly would stand on its brief, which articulated the full explanation why it is not a statute of repose. So in conclusion, Your Honors, we request that the court affirm the order for final judgment dated September 9th, 2019, and the trial court and the trial court's entry of the judgments dated November 1st, 2019, affirm the denial of Mart's motion for entry of judgment pursuant to Mass Rule 58 or 59E, affirm the denial of Mart's motion to leave to amend to assert counterclaims, and affirm a TLT and Western's joint motion to dismiss Canatel's payment bond claim with prejudice and to close case. Thank you, Your Honors.
Thank you, Counsel. Thank you both. The case is submitted. It's under advisement. We appreciate